Welcome to the Supreme Grammar Podcast, where you'll learn to write like a Supreme Court justice. With me, Jill Barton. In this episode, our AI hosts take a deep dive into the analysis section of a motion or brief. The goal here is to show your work with specific, substantive, and parallel analogies and distinctions to supporting case law. Let's listen in.
All right, so you want to know the secret to winning legal arguments?
Well, maybe not the secret.
Okay, not the secret,
Yeah,
but like,
a really important part of it.
yeah, a big piece of the puzzle.
Exactly.
The analysis section.
Yes, the analysis section.
That's where the magic happens in any motion or brief.
That's where you actually win or lose the case.
It's kind of crazy how much rides on that one section.
It's true.
And luckily for us,
Luckily,
Chapter 29 of the Handbook for the New Legal Writer is like a roadmap
it's a great resource.
for making your arguments.
Super persuasive,
Yeah, super persuasive.
but really convincing.
Exactly.
And it all starts with strategy.
Strategy. Okay.
It's not just about knowing the law.
Right.
You have to know how to use it.
So it's not enough to just like drop a bunch of case names.
Nope.
You have to actually connect the dots for the reader.
Exactly.
Like you're building a case.
Brick by brick.
Brick by brick. I
Yeah.
like that.
Yeah.
And the first step is actually outlining your arguments,
Before you even start writing.
which honestly
Wow.
doesn't sound very exciting.
Not the most glamorous part.
No. But I guess that's what being a lawyer is all about.
Right. It's about thinking strategically.
Okay, so we're thinking like lawyers. We've got our outline.
And then we think about the psychology.
The psychology, okay.
Yeah, like have you ever heard of the primacy and recency effects?
I feel like I've heard of those, but
Remind me.
yeah.
Remind me.
Okay, so basically people remember the first and last things they see most clearly.
Oh, right, right.
So you want your opening argument to be a knockout.
A knockout punch.
Yes.
Okay.
And then save a strong one for the end, too.
So you're kind of playing mental chess with the judge,
Exactly.
trying to anticipate how they're going to absorb all this information.
It's all about strategy.
But it can't just be about the order of the arguments, right?
Yeah.
What about the substance?
Ah, yes, the substance.
Each point has to have some weight behind it.
Absolutely.
Like what's actually holding up each argument? Think of it like two legs.
2 legs, okay.
One leg is factual support,
Okay.
and the other leg is legal support.
So you need both
You need both.
to stand strong.
Exactly.
Chapter 29 uses this example of a burglary case,
Oh, yeah, that's a good one.
where the whole argument hinges on.
Whether an area is legally considered part of someone's property.
They call it curtilage,
Curtilage.
which sounds very fancy.
It does.
But basically it's like,
The protected area around your home.
right, so you can't just say, hey, this area is protected.
You have to prove it.
You need details.
You need to paint a picture.
Okay, so like, was there a fence?
Yes. Was there a fence?
How is the space being used?
Exactly. Was it clearly part of the home?
Those sorts of things.
Exactly.
So you're weaving in those facts with the legal definition of curtilage
And that's how you build a convincing argument.
instead of just stating an opinion.
It's the difference between saying something and proving it.
Okay, I'm starting to see how this all fits together.
It's all connected.
So we've got our arguments outlined. We're thinking strategically.
We're bringing the facts and the law together.
And now we need a killer thesis statement.
Ah, yes, the thesis.
This is where things get interesting.
It's more than just a summary.
Chapter 29 points out that it's your chance to start persuading right away.
You're setting the tone for your entire argument.
It's like you're setting a trap,
In a way, yes.
a persuasive trap,
Exactly.
luring the reader in.
And the book gives these contrasting thesis examples from a curtilage case.
Oh yeah, let's hear them.
Okay, so one side argues the defendant's burglary conviction should be affirmed because the picket fence and hedgerow enclosing most of the victim's yard are more than adequate to qualify the area around the home as curtilage.
Wow, that's loaded language.
Right, you've got burglary, victim, home,
You're already feeling sympathy for the homeowner?
before you even hear the rest of the argument. Now compare that to the defense's thesis. Mr. Chapman's conviction should be reversed because the Perry compound does not qualify as curtilage for 3 reasons.
Okay, so they use compound instead of home.
Right.
They humanize the defendant by calling him Mr. Chapman.
And they avoid even mentioning a victim
It's like they're planting seeds of doubt about the whole burglary idea.
before they even get into the specifics.
Sneaky.
Strategic.
I like it.
And this carries through the entire analysis section.
So every paragraph, every sentence
Should be working towards your ultimate goal.
to persuade.
To persuade.
The book even gives a self-editing tip.
Oh, yeah, that's a good one.
Read each paragraph and ask yourself if it's supporting your thesis and your conclusion.
If it's not, it's clutter.
Get rid of it.
Get rid of it.
So each paragraph is like a mini argument building towards the big one.
Exactly.
Speaking of which, topic sentences.
Ah, yes, the topic sentences.
They're like mini conclusions, right?
That's a great way to think about it.
How does that work?
Think of them as guideposts for the reader.
Okay, like signposts along the way,
Exactly.
guiding them towards your conclusion.
Each topic sentence should lay out the mini conclusion you'll reach within that paragraph.
So it's like a preview.
It's a preview, and it also keeps your argument moving.
Momentum.
Yes, momentum.
Okay, so in that curtilage example,
Yes.
you might have one topic sentence about the fence being flimsy,
Right?
another about how the landscaping wasn't well defined,
Exactly.
each one setting up a deeper analysis in the paragraph.
And leading the reader to your desired outcome.
I'm seeing how this all starts to flow together,
It's like building a house.
brick by brick.
Brick by brick. Exactly.
Okay, so we've got our thesis, our topic sentences.
We're thinking strategically.
It's not enough to just list facts.
Right. You have to create a narrative.
A story.
A story.
So the facts are like the building blocks.
Yes.
But you're constructing a story that supports your argument. Like, think back to that example from McCoy v. Louisiana,
Oh, that's a powerful one.
where they painted a picture of the defendant's Sixth Amendment rights
Yeah.
being violated.
They use such vivid language.
Yeah, like, because of English's conduct, McCoy had no way to present his defense but to testify himself, and to do so under the pall of an admission of guilt by his attorney.
That's heartbreaking.
It is. You really get a sense of how unfair the situation was.
And the repetition of "and" just adds to that feeling of being overwhelmed.
Like they're piling on.
Exactly.
But what about when you're arguing against something?
You mean like a counter-argument?
Yeah. Can you still use storytelling to your advantage then?
Absolutely.
Okay, how so?
The book contrasts this with DC v. Westby,
Okay.
where they used parallelism to highlight the lack of evidence supporting the other side's claims.
Parallelism.
Yeah, like they kept saying no transcript, no letter, no police report.
Oh, I see.
It's like they're creating a void where the evidence should be.
And making their point through omission. Interesting how language can be used in so many ways to shape the reader's perception.
That's the power of persuasive writing.
But of course, we can't forget about legal precedent.
The case law.
Chapter 29 says we need to use it through analogies and distinctions.
2 key tools in your legal writing arsenal.
Can you break those down for us?
Sure, think of an analogy as finding your legal twin.
Okay, a legal twin.
You're saying, hey, this case over here had similar facts and the court ruled this way.
So my case should too.
Exactly. That's like saying, hold on, that case looks similar, but there's this key difference.
That means it shouldn't apply here.
You got it.
So it's all about finding the right cases to support your argument.
And explaining away anything that seems to contradict it.
But Chapter 29 stresses that these comparisons have to be more than just surface level.
They have to be substantive, parallel, and specific.
Okay, break that down for me.
Substantive means your comparison has to be tied to the legal issue you're arguing.
Okay, it has to be relevant. What about parallel?
Parallel means comparing apples to apples.
Not apples to oranges.
Exactly.
Okay, and specific.
Specific means using concrete details to make your point.
So no vague statements like, this case is just like that case.
Right, you need to show exactly how they're similar.
And why that matters for your argument.
Precisely.
Okay, so give us some examples of how to do it right.
Let's say you're arguing that someone didn't meet the open and notorious requirement for adverse possession.
Okay, I remember that from property law.
You might say, car only camped on the property 7 times in 6 years and left the cabin in disrepair. This is similar to Klein, where the court found that occasional picnics on a vacant lot with unkempt landscaping didn't meet the open and notorious standard.
Okay, so you're using specific details.
And drawing a clear parallel between the 2 cases.
Showing how the facts in Klein are similar to the facts in your case.
And why that means the same legal standard should apply.
Okay, what about a reasoning analogy?
For that, you'd focus on the court's logic in a previous case.
So you're not just looking at the facts.
You're looking at the reasoning behind the court's decision.
Okay, give me an example.
Imagine you're arguing someone shouldn't be convicted of burglary because they innocently wandered onto a property.
Okay, like they didn't have intent to commit a crime.
Exactly.
Okay, so what would the analogy be?
You could say, Mr. Chapman entered the Perry compound because it was open and unbounded, similar to the JL case, where the court held that the burglary statute wasn't meant to punish someone who simply entered an open yard to pick fruit from a tree.
So you're highlighting how the court's rationale in JL,
Applies to your situation.
because in both cases, the person didn't have criminal intent.
Exactly.
Okay, so that's a reasoning analogy,
And then there's the holding analogy.
which is the most direct.
Okay, so you're basically saying,
A court already ruled this way in a case with similar facts.
so you should rule the same way here.
Boom, mic drop.
You could say, sporadic fencing and landscaping don't constitute a sufficient enclosure for a burglary conviction. This is consistent with Hamilton, where the court reversed a conviction because several unevenly spaced trees didn't create a proper enclosure.
So you're pointing to a precedent that directly supports your desired outcome.
That's the power of a holding analogy.
Okay, so we've got analogies.
These distinctions.
Right. Those are for when a case seems to go against your argument.
Exactly.
Chapter 29 mentions using parentheticals to weave in case law.
Parentheticals are your friends.
Give us an example.
You might write, Carr's actions weren't open and notorious, as he only camped on the property 7 times in 6 years and left the cabin in disrepair. C. Klein, holding that occasional picnics on a vacant lot with unkempt landscaping did not constitute open and notorious possession.
So you're giving a concise summary of the relevant case law without interrupting the flow of your argument.
It's like a little legal footnote.
But we also need to talk about those distinctions.
Right, because not every case is going to be on your side.
So distinctions are your way of explaining away those pesky cases that seem to contradict your position.
You're highlighting the key differences that make the unfavorable case inapplicable.
Okay, give me an example.
Let's say you're arguing that a police checkpoint set up to gather information about a hit and run is constitutional.
Go.
But there's a precedent where a drug checkpoint was deemed unconstitutional.
Oh, that's not good.
Right, but you can distinguish the cases.
Okay, how?
You might write, this informative checkpoint doesn't threaten the Fourth Amendment. Unlike the drug checkpoint in Edmond, it's limited to one specific crime and tied to the roads. The officers had little discretion in setting it up. It's not like the overbroad drug checkpoint in Edmond that the Supreme Court struck down.
So you're acknowledging the unfavorable precedent.
But showing why it doesn't apply to your case.
Because of those key distinctions.
Exactly.
It's like legal judo.
Using your opponent's weight against them.
I like it, but even with the strongest arguments, there will always be counter-arguments, right?
Unfortunately, yes.
Chapter 29 talks about anticipating those and addressing them head-on.
It's crucial.
Why is that so important?
Because it's about controlling the narrative.
Okay, I like that.
If you ignore potential weaknesses
Your reader might latch onto them.
and doubt your entire argument
So you're basically preemptively disarming a bomb.
before it can explode and damage your case.
Okay, how do we do that effectively?
You have to think like opposing counsel.
Put yourself in their shoes.
Exactly. What are the weak points in your case?
Are there any cases that could be used against you?
Anticipating those challenges allows you to control how they're presented.
It's like planning your defense before you even get attacked.
Exactly.
So you're not just reacting.
You're being proactive.
Okay, that makes sense.
But remember, you don't have to address every single potential counterargument.
Oh, really?
Sometimes silence is golden.
So if a counterargument is weak or obscure,
Addressing it might give it more weight than it deserves.
it's about picking your battles strategically.
Exactly.
But when you do address a counterargument, how should you approach it?
Don't be defensive.
Okay.
Use the facts and the law to your advantage.
Reframe potential weaknesses as strengths.
Precisely.
Give me an example.
Imagine you're representing a defendant who's elderly and has dementia, which could make them seem vulnerable.
Right.
But instead of ignoring it,
You could say.
the plaintiff is an active 92-year-old who traveled alone to Texas 6 days before the incident and completed a 50-kilometer bicycling race.
Wow, so you're turning a potential weakness into evidence of their resilience.
Exactly.
That's clever.
It's all about framing
Because you're flipping the script and using what could be seen as a negative.
to actually bolster your argument.
I like it. And where should we place these rebuttals within our analysis section?
Placement is key.
Does it matter?
Absolutely.
Why?
Remember those primacy and recency effects we talked about?
The first and last things people remember.
Exactly. So you want your strongest arguments at the beginning and end,
Okay.
and tuck those rebuttals away in the middle.
Where they're less likely to overshadow your main points.
Like a legal sandwich.
A legal sandwich, I like that.
Strong arguments on the outside.
A thin layer of counter-arguments in the middle.
Exactly.
But even with all this talk about strategy and technique,
It's easy to get lost in the weeds.
Chapter 29 reminds us that Legal writing
especially in the analysis section.
should be clear and concise.
Above all else,
Why is that so important?
judges are busy people.
They don't have time to waste.
They're not going to wade through convoluted sentences and legal jargon.
So no rambling or fancy words.
Oh, just get to the point.
Make it easy for them to understand your argument.
Exactly.
And proofread.
Yes, typos and grammatical errors can undermine even the most brilliant legal argument.
It's like showing up to court in sweatpants.
Not a good look.
Well said.
This has been an incredible deep dive into the art of persuasion.
I'm glad you enjoyed it. I feel like I've leveled up my legal writing skills already.
That's what we like to hear.
So are you ready for part 2?
Absolutely. Let's dive deeper.
All right, let's do it.
Okay.
So last time we were talking about analogies and distinctions, and you said...
Substantive, parallel, and specific.
Right, those are the
Key ingredients
for making those comparisons really count.
for making them strong.
So substantive means
It's got to be tied to the legal issue.
the actual issue at hand,
Exactly.
not just some random similarity.
No, it's got to be relevant.
Okay, got it.
Parallel means you're comparing apples to apples.
Not apples and oranges. Specific means.
Concrete details.
So paint me a picture.
Show me exactly how those cases are similar.
Not just like, oh, they're both about contracts or something.
Right, you need to dig deeper.
Okay, so give me an example.
Let's say you're arguing that a certain area didn't count as curtilage for a burglary charge.
Curtilage, that's the...
The protected area around a home.
Right.
So you might say something like,
Like what?
the defendant only walked through a small section of the yard, nowhere near the house or any outbuildings. This is similar to the Miller case, where the court found that simply crossing a corner of an unfenced field didn't qualify as entering the curtilage.
Oh, I see.
You're showing a parallel.
Between the actions in your case and the actions in the Miller case.
And using that to argue that the same legal principle should apply.
Okay, so that's how we use analogies.
But what about when there's a case that seems to go against your argument?
Yeah, those pesky precedents that make things tricky.
That's when you use distinctions.
To explain away the seemingly bad case.
Exactly.
How do we do that?
Again, it's got to be substantive, parallel, and specific.
Okay, so give me an example of a distinction.
Let's say you're arguing that your client's confession shouldn't be admissible in court.
Because it was coerced or something.
Right, but there's a precedent where a confession was deemed admissible even though the police used some questionable tactics. So you need to distinguish that case. You might say something like, unlike in the Jackson case, where the defendant confessed after only a few hours of questioning, our client was interrogated for over 12 hours without food or water.
I see.
You're highlighting a key difference.
The length of the interrogation.
That makes the Jackson case less relevant to your client's situation.
So even though the police used questionable tactics in both cases.
The circumstances were different enough to warrant a different outcome.
Okay, I'm starting to see how this all works.
It's all about building a strong foundation for your argument.
Brick by brick.
Exactly.
So we've got analogies, we've got distinctions.
We're using case law to our advantage.
But Chapter 29 also talks about anticipating counterarguments.
Oh, that's a crucial part of persuasive writing.
Why is that so important?
Because if you don't address potential weaknesses in your argument,
The reader might latch onto them.
and start doubting your entire case,
So it's better to preemptively address those counterarguments.
control the narrative.
Okay, but do we have to address every single counterargument?
Not necessarily.
Sometimes silence is golden.
Exactly. If a counterargument is weak or obscure,
Addressing it might give it more weight than it deserves, so it's about picking your battle strategically.
exactly.
But when you do address a counterargument, how should you approach it?
Don't be defensive.
Okay, so don't be like, oh, but they're wrong because...
Right, you want to reframe those potential weaknesses as strengths.
Turn those lemons into lemonade.
Let's say the other side argues that your client's testimony is unreliable because they have a history of mental health issues.
Okay, that's a tough one.
But you could address it by saying something like, while our client has faced challenges in the past, they have sought treatment and are now a stable and reliable member of the community.
So you're acknowledging the issue,
But you're reframing it in a positive light,
showing that your client has taken steps to address their past struggles.
and that they are now capable of providing truthful testimony.
Okay, that's a good strategy.
And remember, placement is key.
Placement of
those rebuttals.
Right, because we talked about
The
the first and last things people remember,
You want to bury those rebuttals in the middle of your argument.
where they're less likely to overshadow your main points.
It's like that legal sandwich we talked about.
Strong arguments on the outside.
Counter-arguments tucked away in the middle.
Okay, I'm getting hungry now.
Me too.
But seriously, this is all great advice.
It's all about being persuasive
Making your arguments as strong as possible
and anticipating the other side's moves.
so that you can win the case. All right, so we've talked about analogies, distinctions, counter-arguments.
We've covered a lot of ground.
Yeah, we've really built up a solid foundation for writing a persuasive analysis section.
But there's always more to learn.
Right, and Chapter 29 hints at some next-level stuff, too.
Like what?
Well, it mentions the psychology of persuasion.
Oh, yeah, that's where things get really intense.
So are we talking about, like, mind control or something?
Not quite mind control.
Okay,
But it's definitely about understanding how people process information.
and using that to your advantage.
Exactly.
So it's not just about cold, hard logic,
It's about tapping into emotions.
making the reader connect with your argument on a deeper level.
That's the key to true persuasion.
And one of the most powerful tools for that is
Storytelling.
storytelling, okay?
Humans are wired for stories.
We love a good story.
We remember them, we relate to them.
And we're more easily persuaded by arguments presented within a compelling narrative.
It's like slipping the medicine into a spoonful of sugar.
Instead of just stating facts.
You weave them into a story that pulls the reader in.
I'm starting to see how those examples from McCoy v. Louisiana and DC v. Wesby were so effective.
They were telling stories.
Stories that evoked specific emotions.
Exactly.
And then there's the art of framing,
Ah, yes, framing.
which is all about
Choosing the right words.
to present your argument in the most favorable light,
It's about setting the stage.
creating a context that makes your position more palatable.
Exactly.
So it's like choosing the right filter for a photo
You're highlighting certain aspects and downplaying others.
to create the desired effect.
Precisely.
And this all comes down to word choice, right?
Every word counts.
Chapter 29 really emphasizes using clear, concise language.
Avoiding jargon and legalese.
So no showing off our fancy vocabulary.
Nope. Clarity trumps complexity.
You want the reader to focus on the substance of your argument.
Not get lost in a maze of technical terms.
Okay, but what about those rhetorical devices we learned about in English class?
Like metaphors and analogies.
Yeah. Do those have a place in legal writing?
They absolutely do.
Really?
Used strategically, they can add depth and nuance to your arguments.
Give me an example.
Let's say you're arguing that a contract is unfair.
Okay.
You could compare it to a trap that ensnares unsuspecting parties.
Ooh, that's a vivid image.
You instantly get a sense of wrongdoing.
And you sympathize with the victims.
Exactly.
It's way more impactful than just saying the contract is unjust or unbalanced.
Right. Or you could use an analogy,
Like what?
comparing the contract to a rigged game where one side has an unfair advantage
So you're drawing on familiar concepts
to illustrate complex legal issues.
and sway the reader to your side.
Exactly.
It's like sneaking in a little bit of poetry.
To spice up the legal prose.
But Chapter 29 cautions against overusing these techniques, right?
A little goes a long way.
Too much of a good thing can be a bad thing.
Exactly. Overusing rhetorical devices can make your writing feel forced.
And distract from the substance of your arguments.
It's all about finding that balance.
Between being persuasive and maintaining credibility.
You want to be convincing, but not manipulative.
Right. You want the reader to trust you.
Exactly.
So this has been an incredible deep dive into the art of persuasive legal writing.
It's been a pleasure exploring these concepts with you.
I feel like I've learned so much.
I'm glad to hear it.
And I'm definitely going to be putting these techniques into practice.
That's what it's all about.
For all you aspiring legal eagles out there.
Keep those arguments sharp and your writing even sharper.
Until next time, happy writing.
The best legal writers show their work in the analysis section, with clear analogies and distinctions that make complex arguments easy to follow. For more tips, see Chapter 29 of the Handbook for the New Legal Writer. And remember, you can be a great legal writer.